Hello my dear friends, welcome to the Canadian Law Stream. In this section of our video, we would be dealing with the second source of Canadian constitutional law. The second source of Canadian constitutional law is the Constitution Act of 1982. It was passed in the year 1982. It is a very important act which brought a landmark in the Canadian system, and we will discuss more about it in this video. So the Canadian Constitution Act of 1982 made three important changes to Canada's constitutional law. The first is the domestic formula of amending the constitution was adopted by this act. As you people are aware, since we discussed in the previous video that the British North America Act of 1867 did not have any provision relating to the amendment of constitution, an amendment of the act. If the British North America Act had to be amended, there was no provision within the act which could amend it. So a separate Imperial Statute had to be passed by the Parliament of United Kingdom in order to bring amendments to the British North America Act of 1867. So there was no domestic formula within the act through which it could be amended when the need arose. So by this act of 1982, an internal mechanism was followed through which a section was created under this act by which the Act of 1982 could be amended. We do not have to be dependent on the Parliament of UK to pass an Imperial Statute in order to amend the Constitution of 1982. It could be amended from within. There is a provision now. The second is the authority over Canada of the United Kingdom Parliament was from 1982 terminated. So the UK Parliament had no authority over the territories of Canada anymore. So in the British North America Act of 1867, you saw that the UK Parliament was having a legislative authority over the British North American territories. But from now onwards, there would be no authority of the Parliament of UK, which is called as the Imperial Parliament, to enact laws for Canada. The internal system of Canada would be sufficient for itself for the enactment of laws. The federal government could enact laws on areas pertaining to federal subjects, and the provincial government could enact laws on areas pertaining to the provincial subjects. In the British North American Act of 1867, there were three powers which could enact laws. First was the federal government of British North America, and second was the respective provincial governments of British North America, and the third was the Parliament of UK. There were three bodies authorized to enact laws over the British North American territories. But from now onwards, only two bodies would be allowed to make laws over the British North American territories from now onwards, which would be called as Canada. And that would be the federal government of Canada and the provincial government of Canada. No more the Parliament of UK. Now, there is one more important thing which I have to mention here. The phrase Constitution of Canada was adopted for the first time and used for the first time in this Act of 1982, the Constitutional Act of 1982. First time the phrase Constitution of Canada is being used. And moreover, I'll also like to mention that this act had renamed the previous British North American Act of 1867 as the Constitution Act of 1987. So from now onwards, if any inference had to be made to the British North American Act of 1867, The term Constitution Act of 1867 should be used instead of the British North American Act of 1867. Now, let us discuss in detail about the provisions and about the provisions of the Constitution Act of 1982. Now, the first thing first. The Constitution Act of 1982 in section 52 subclause 2 defined constitution for the first time. It says that Constitution of Canada includes the following things. First, what does it include? Let's see. The first thing which the Constitution of Canada includes is the Constitution Act of 1982 itself. Second, 30 other acts and orders including the Constitution Act of 1867, or in bracket the British North American Act of 1867. So 30 other acts and orders also becomes part of the Constitution of Canada, including the British North America Act of 1867, which from now onwards will be called as the Constitution Act of 1867. And third, any amendment which is made after it, any amendment made would also be a part of the Constitution of Canada. So the definition Constitution of Canada as defined under section 52 subclause 2 of the Constitution Act of 1982 includes three things. First, the the Constitution Act of 1982 itself. Second, 30 other acts and orders including the Constitution Act of 1867. And third, any amendment which may be made thereafter. Now, it is also important to mention here that the Charter of Rights, which is called in different countries by different names. In India, it is called as fundamental rights, and in Indian constitutional setup, it is dealt under Part 3. Part 3 of the Indian Constitution deals with fundamental rights. In the same way, the Charter of Rights are dealt under Part 1 of the Constitution Act of 1982. So Part 1 of the Constitution Act of 1982 deals with Charter of Rights, which is known by different names in different countries. For example, in India, as we discussed, it is known as fundamental rights. So section 52 subclause 2 of the Constitution Act, which defines the term Constitution of Canada, includes the following things. Now, it is also important to mention here that since I take classes with criticism, I also criticize the nuances which are there in the Canadian constitutional setup. So one criticism is that the definition of the Constitution as given in section 52 subclause 2 is not exhaustive. Because it uses the word includes. It says the Constitution of Canada includes. It doesn't say the Constitution of Canada means. That means there's scope of adding more things. If I want to add tomorrow one more thing, then I could add it, because it is not exhaustive. So there's a lot of scope of interpretation of laws, and new things can be added tomorrow if the court feels so. Supreme Court of Canada feels so, then new things could also be added into this definition of Constitution of Canada. Now, there is one principle that I like to discuss with you people, and that is the supremacy of the Constitution of Canada. You see, section 52 subclause 1 talks about the definition, subclause 2, sorry. Section 52 subclause 2 talks about the definition of the Constitution of Canada. Section 52 subclause 1 on the other hand, talks about the supremacy of the Constitution of Canada. It says that any law that is inconsistent with the provisions of the Constitution, that law, to that extent of inconsistency, will be of no force or effect. That means any law which violates any of the provisions of the Constitution of Canada, to the extent of violation, that particular law would be rendered ineffective, unconstitutional. So it gives priority to the Constitution of Canada over other laws. Any law which is inconsistent with the Constitution of Canada would not be put into effect, and to the level of inconsistency, it would be turned unconstitutional. Now, there is one more important principle in the Canadian uh, constitutional system, and that is the principle of entrenchment. Entrenchment is a kind of extra legal safeguard which is attached to law in order to make it supreme. So since you know that the constitutional law is the bedrock of all laws, it's the most supreme of all laws in a country. So a special place has to be accorded to such laws. So the Canadian Parliament has provided the system of entrenchment. That means extra legal safeguards have been attached to the constitutional law of Canada, and that legal safeguard pertains to amendment as well. Part 5 of the Constitution of Canada Act 1982 deals with amendment of the Constitution. See how those legal safeguards are being put to play. I'll explain it over here by giving the example of amendment. See, amendments to the Constitution of Canada shall be made only in accordance with the authority contained in the Constitution of Canada. So if an amendment had to be brought in, then it had to be brought in only by the way and mechanism mentioned in the Constitution Act of 1982. Any amendment to the Constitution of Canada cannot be brought in through any other way not mentioned in Part 5 of the Constitution Act of 1982. So you see, the Constitution of Canada cannot be amended by any ordinary legislative action. It can only be amended by a special amending procedure laid down in Part 5 of the Constitution of Canada Act 1982. So in order to amend the Constitution of Canada, if the Parliament feels so, then what is the process it has to undergo in order to amend it? It has only one way, and that is to use a special amending procedure mentioned in Part 5 of the Constitution of Canada Act of 1982. So what is the reason of providing such extra legal safeguard or extra entrenching provisions to the Constitution of Canada under Section 52 subclause 3? The first reason is, which I believe, is that fundamental rights and civil rights of Canada, they are required for an orderly working of society. That's a very basic natural human right which is prevalent in all countries. Even in India, fundamental rights are there. If any person is deprived of his or her fundamental right, then his output of living as a human with dignity is compromised. So the Charter of Rights, being very supreme and which are necessary for the fulsome enjoyment of human opportunities, they are required. So extra safeguards have to be provided in order to protect those fundamental rights, fundamental human rights and individual freedoms. So this is the reason why, if those freedoms are to be snatched, then a special amending procedure has to be followed in order to amend those rights. Second, which I believe, is Canada is a country which was originally inhabited by the Aborigines, the Inuits, the Métis people, the Algonquin people. So there are special communities which need extra protection because they are vulnerable minority groups, and in order to protect them, the constitutional scheme has to be very strong. The ways in which an amendment has to be brought in order to snatch those fundamental protection given to them cannot be very easy. It has to be a very special one. So in order to protect those minority vulnerable groups, I believe that special legal safeguards are necessary, and that's the reason why the entrenchment clause of section 52 subclause 3 presumes importance. The third reason is, since Canada works under the system of separation of power, so division of power and political authority amongst different levels of government demand that they not be diluted, and an extra protection has to be given to them. So the entrenchment clause assumes significance under section 52 subclause 3 of the Constitution Act of 1982. So the two principles which I have discussed today are very important. First, section 52 subclause 1, which deals with the supremacy of the Constitution, and section 52 subclause 3 of the Constitution Act of 1982, which deals with the retrenchment clause, which talks about the extra legal safeguards that has to be provided to the Constitution of Canada. Thank you, friends. I hope you like this video.